Tensions got high, and I had stood up and
This was file 25191870 SM, People versus Jonah Michael McLean. That's you, sir?
yes, sir.
Here with your lawyer, Mr. Ross Truckee, also present is Angelique Campfield from the prosecuting attorney's office. You were here last Friday, October 3rd, which was a very, very busy day.
Very busy.
There was an issue regarding the bond. And then there was another issue regarding the bond. We took 28 pleas that morning, and you waited for 4 hours, and it was 1 o'clock, and I had to then start the afternoon docket.
Yes, sir.
You're charged with interfering with a crime report, which essentially deals with taking a telephone away from somebody. This one isn't in my queue, as I said, but I've got it here. And 2 counts of domestic assault upon Alexis Ayers, your girlfriend. When you posted bond, you were given instructions to contact community corrections regarding pretrial supervision, and you never did.
I did contact them, Your Honor. I've called her numerous times, and I'm at work for a shift, and I'm not allowed to have my phone.
All right, well, we'll see if we can get the case on track. Rather than do a warrant, I simply set this for a hearing. And these things were all matters that we didn't have time to do on Friday. I set some of these on a real short turnaround, Friday to Wednesday, but this day was wide open. And I wanted to put some things in here, so I appreciate the prosecutor's indulgence. Anyway, I'll defer to you first, Mr. Truckee. What's our status here today?
It appears we can resolve this with a plea to 1 count of domestic violence, and the prosecutor consents to the deferral program for which Mr. McLean appears eligible. Additionally, pending sentencing, I believe victim is here, and we would like to be heard on no contact orders.
All right, well, we may be able to go right to sentence today if that's agreeable with everybody. All right, Ms. Campfield, as you know, we are all crunched for time on Friday.
Correct.
This is an offer to 1 count of domestic violence, and the prosecutor does not object to the deferral.
That is correct, Your Honor. Mr. Truckee and I wanted to research the deferral statute and the definition of an assaultive conviction because there are 2 old convictions about 10 years ago.
From where?
From our county.
I didn't find them.
They may have been, well, they're listed as 45th Circuit, so.
Okay, there were, yeah, he has a couple cases that got bound over. They were B&E type cases.
There was a breaking and entering in a home invasion 2nd degree that lists a conviction. And at least my judicial segment on lien indicates 365 days in custody with no probation as near as I can tell. So I think that the services here through our diversion program are needed and warranted. It appears neither of those prior offenses fall under the definition of an assaultive crime, even if they're in a person category. So we're okay with him taking advantage of this program, and that's what I would recommend.
All right. Well, let's talk about that, Mr. McLean. Let me get back to this case. The more serious charges, it's also kind of ironic a little bit. Assaulting somebody in domestic assault is a misdemeanor punishable by up to 93 days in jail. You slap them in the face, punch them in the stomach, that's 93 days in jail. If you take their phone away from them, that's a misdemeanor punishable by up to a year in jail, fine of up to $1,000, actually more serious than the assault did through the use of physical force prevent someone from reporting a crime. They're agreeing to dismiss that and one count of the domestic violence and plead to one count of domestic violence. As I said, that's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Unless you successfully complete the deferral, you would not be able to use or possess a firearm for at least 8 years. With the deferral, I can do it with the consent of the prosecutor only. I can't do it unless they agree, but here they agree. I would put you on a probation with supervision that would include no assaultive or threatening behavior, no drugs or alcohol, and a domestic violence treatment class. And if you complete all that, the charge could be taken off your record. I'd put you on probation for 12 months, and if you could complete the program in less than that, you could be discharged potentially as early as 6 months. Do you understand?
Yes, sir.
Other than what I just said to you, did anybody promise you anything to get you to plead to this
No, Your Honor.
or threaten you?
No, sir.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand?
Yes, sir.
I could appoint an attorney for you. In fact, I've done that. Mr. Truckee is here with you. And you could also hire your own lawyer of your own choosing if you wished, although Mr. Truckee is doing a fine job on this case. If you had a trial, you'd have the right to be a witness for yourself. You could testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. You'd have a right to have any of the witnesses for or against you subpoenaed to come to court, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir.
Now, the complaint says that this happened on September 13th in Sturgis Township. We look a little farther. That address is just outside the city on Texas Avenue. What's the name of that apartment complex?
Townhouse.
All right. Were you, Miss Ayers, living together at that place?
Yes, Your Honor.
And on that day, did you get into an argument?
Yes, sir.
Do you remember what you were arguing about?
The employment and just social things like talking to certain people. The normal jealousy kind of argument. Tensions got high, and I had stood up and stood my ground in a certain moment, and kind of sparked, I guess, a little fear into her, as well as I shoved her back into the couch away from me, and that sparked
All right, it says that
the next set of.
poked her in the chest and pushed her onto the couch.
Yes, sir.
Ms. Canfield, are you satisfied with the factual basis?
Yes, Your Honor, I think that satisfies.
Mr. Truckee?
Yeah, that meets the elements.
All right. Now, normally in a domestic violence case, the law says I'm supposed to continue the matter at least 10 days to make sure that I get victim input. But if I understand correctly, our victim, Ms. Ayers, is here. And if the prosecutor's willing and she's willing, I'm willing to just go right to sentence. Ms. Ayers, would you come forward, please? Good morning. Are you Alexis Ayers?
Yes,
You brought two small girls with you this morning. Are those your children?
yes, sir.
Are they Mr. McLean's children as well?
They might as well be. He's raised them.
So he's the father figure to those
Yes.
girls? And you all live together at that Texas Avenue
Yes,
address? Do you have any objection to this program where I put him in treatment and do a deferral?
No, sir, that is exactly what I asked for, is for him to get help with his mental health.
Were drugs or alcohol part of this
No,
incident?
sir.
I did not get that impression. Now, it's almost always, not every single time, but nearly in a domestic violence case, we have a bond condition that the defendant not have any contact with the complainant. Means they gotta move out, means the kids can't see dad, everybody's out of the house. There are several reasons for that. Often, in the old days, the defendants would try to intimidate the witness. Please don't testify against me. I love you. I love you. I won't do it again. Or if you testify, I'm gonna beat you up. We don't want that. Also, maybe they need a timeout under the theory that you don't know what you got till it's gone. And so he's had a no contact provision. This was the 13th of September. You were here Friday, weren't you?
Yes,
And it was terrible. Your kids were here and there were a million people here and we never got to your case. So do you want me to lift the no contact provision so that he can
Please,
move
sir.
home?
my kids miss him very much.
Mr. McLean, have you ever been previously convicted of a domestic assault?
No, sir, I think I had some kind of assault case as a juvenile in a school fight. I think those charges got dropped. I honestly cannot remember.
I couldn't find them, but it doesn't appear you've had anything assaultive. You had a bad luck streak in dancing school in the teens. You got several B&Es and took your lumps, but I didn't see any assaultive stuff.
Yeah, I was a not very bright teenager.
Well, that happens often. How long were you in jail?
On those charges, consecutive, I mean,
No, this charge.
the
This happened on the
Saturday-
13th and you posted
Saturday.
bond on the 15th. I think you did 2 days in jail.
2 full days, yes, sir.
I'm gonna put you on probation for 12 months. I'm gonna order 12 days, credit 2 of the 12 days, 10 are deferred. These days are deferred for you to complete the terms of this probation. I'm gonna make the fine 0. Your family needs the money more than the court does, and there's enough other stuff that needs to be paid here. There's a $75 crime victims' rights fee and a $50 state minimum fee that go on every single case. There's a $150 attorney fee and there's a $480 probation oversight fee, and you pay for the class. This appeared to be more of a shove, although she says this has happened before. They didn't find any injuries. I'm gonna order the anger management class. Let's add up that amount. 125 plus 150 plus 480. 755. Every month, less than 12 months, you do this, saves $40. Payment is due in 1 year. Now here's your conditions. No assaultive or threatening behavior. That's less than domestic assault. If you're yelling at her out in the yard, or you're yelling at her about an unpaid bill, or the kid's crying, that's assaultive or threatening behavior and violate your bond.
Okay,
You're not to use any drugs or alcohol. That's on everybody's probation. And we're gonna test you periodically to make sure that you don't. And you're gonna complete the anger management course, which will be directed to you by the probation department. Those are 2 beautiful little girls. And they spent 4 hours in here on Friday. It was very hectic. this, and Ms. Canfield, I appreciate this. We have the whole morning. We had time to address this. Trying to do this on Friday was just not feasible. But now we can do it at our leisure. I get to hear from the complainant. Your family deserves better.
Yes, sir.
You need to get a job and,
Sir.
all right, where are you working?
Harmon Tube in Sturgis. I got that job like 24 hours after getting out of jail that Monday.
Very good.
We concede that she was right about yelling at him to get a job.
Well, and he did. They need support. You take this downstairs to the probation department. Now, the no contact provision is lifted. You're not on bond anymore, you're on probation. And the condition of the bond, the probation is no assault or threatening behavior. So if you do it, you're gonna end up back in jail. I want you to do what I ask you to do, and if you do that, this conviction would be made non-public. There would be no public record of conviction. Do you have any questions?
I don't believe I do, Your Honor.
All right, you take that down to the probation department. I want you guys to start to reconcile here. And we're gonna work on these issues with the treatment program. All right, sir, you're good to go.
Thank you.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.